Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, dear students. First of all, I'd like to apologize for my absence today in the physical classroom because of another program that I cannot leave it. The first meeting with Chris, you have already discussed about the stages of international business contract. I'm sure that we have already discussed every stage of the international business contract. Now I would like to come to the earliest stage of making international business contract, which is commonly called as MOU or Memorandum of Understanding, or you can also call it as letter of intent or letter of understanding, and so on and so forth. Okay, it is very common that before the parties make or create a contract, the parties create an MOU. And to discuss what is MOU and several aspects related to it, I'd like first of all to deliver about what we are going to discuss today. The first one is introduction, and I would like to explain why parties come to the MOU. And the second, we will discuss about MOU or letter of intent based on study of cases or case studies. Okay? And in the third part, we will discuss about legal considerations in the sense of theoretical synthesis. And the fourth, I would like to offer some advice to negotiators. And the last one is conclusions. For the first one, the introduction, I'm sure that Chris has already discussed about the earlier stages of making international contract. Okay, especially when a contract relates to a complex and wide-reaching operation. The negotiations or the performance may take months or even years and will require the cooperation of several enterprises. Imagine, for example, the contracts like complex mergers and acquisitions contracts, agreements relating to the turnkey constructions of a factory, or to integrated production of civil or military aircraft, the explorations or extraction of natural resources, and then long-term supply contracts for primary materials or the transfer, exchange or joint implementations of new technology. If you imagine such kind of examples of the international contracts, then you will find that the legal structure covering such operations of the contract is necessarily very, very intricate. Sometimes there are a number of interdependent contracts with numerous and often complex clauses seeking to join provisions that are essentially technical with others more specifically legal. The legal structure covering such operations is necessarily very intricate. Sometimes there are a number of interdependent contracts with numerous and often complex clauses seeking to join provisions that are essentially technical with others more specifically legal. The negotiations of such contracts are long and difficult, okay, because of the complexities of the contract, of course. Between the initial definitions of the common objectives and the signing of the final agreements, there is a slow work process from preliminary studies and then obtaining the necessary assistance from third parties, for example, financing and insurance, applying for governmental permits that will eventually be required, and ultimately refining the details related to various aspects of the agreement between the parties. For example, specifications, periods for completion and delivery, determinations of prices, clauses, providing for variations and supervening events, guarantees and guarantees of performance, arbitration, and so on and so forth. Such negotiations and the various stages involved may take years. Not infrequently, the discussions continue after the start of performance of the contract, when the urgency of the project drives the parties to proceed with operations before the contractual documents are fully completed. During the prolonged gestations of their agreements, the negotiators often feel the need to create a series of preparatory documents. At the start, such documents set out the purpose and scope of the discussion to come, and they spell out procedural aspects. As the discussions proceed, the results are recorded. Certain basic agreements may be accepted, while specific details remain to be determined. Sometimes such documents are intended to inform third parties whose involvement is sought. At other times, it is some third parties who, upon the request of one of the principal parties, provide written assurance of their eventual involvement. So this may be known to the other principal party. Any such preparatory documents, as I mentioned, are frequently titled letter of intent or memorandum of understanding, and there are other terms also like protocol, letter of understanding, agreements in principles, and you may also ever heard what is called as heads of agreements, and so on and so forth. The frequency of their use in practice has led to the common use of their abbreviations such as LOI, MOI, LOU, MOU, and so on. So when we talk about LOI, letter of intent, in the same meaning or interchangeable terms like Memorandum of Understanding, Letter of Understanding, sometimes also it is called as protocol, okay, agreement in principles, and uh, also heads of agreement. Okay. So let's start about what is the meaning of LOI or MOU. Okay. Of course, you can browse about the definitions in various sources, but I'd like to uh, deliver one of the definitions about the LOI is any kind of pre-contractual document by which one or both parties intend to organize the negotiations and executions of the contract. You may also say that LOI is a wide and encompassing variety of pre-contractual documents. In practice, LOI, MOI, LOU, MOU, HOA are used in an interchangeable manner and have no precise significance. So you may use the term LOI, you may also use MOU, LOU, HOU, HOA, and so on. Okay. However, some believe that MOUs and heads of agreements belong more specifically to the category of letters of intent, stating the results of negotiations already achieved, which need not be discussed again. So it's like the results of preliminary negotiations in the form of MOUs. Okay. Then the questions related to the MOU, related to the LOI, is usually that related to legal nature or the binding force of the LOI or MOU. Okay. When we access some resources, okay, we will find that legal nature of the MOU or LOI is unclear. Okay. Sometimes it is stated that no obligations, although there sometimes harbor the thought that they might obtain a commitment from the other party. One also may gain the impressions that certain letters of intent or certain clauses contained in such letters do create at that stage certain legal obligations on the part of their signatories. So from here, it is why it is said that the legal nature of the MOU or the legal of the letter of intent is unclear, because it may raise an obligations and it may also not. Okay. Even the impressions that the certain letters of intent or certain clauses contained in such letters do create at that stage certain legal obligation on the part of their signatories. So it is different from common understanding about the LOI or MOU. Okay. Here, I would like to discuss about the working group on international contracts in the study of letters of intent. The working group on international contracts, or I would like to say that WG, studied about more than 100 letters of intent or similar documents or analogous documents created at whatever stage in negotiations and appearing to constitute some part of the progressive elaborations of the final contract were brought together, whatever the characterizations the parties might have given them. And the results of the study sorted into two categories. Firstly, those that could be classified into some non-legal category. So there are some groups of letter of intent that can be classified into legal categories, such as offers to contract, final contract's appearance to the contrary notwithstanding, and contract subject to condition precedent. And secondly, they are categorized as true letters of intent, so the real subject of the study. And then the working group look into several aspects when talking about or when studying about the letter of intent or MOU. The first one is the circumstances in which such letters were drafted, and then the second one, their intended purposes. So what are the purposes of the MOUs or the letter of intent, and the legal effect that one could attribute to them, and the guidance they could give for the conduct of negotiations. Okay, so when the working group of international contracts in study of letters of intent evaluate the groups of hundreds letters of intent, then the working group has resulted in several findings. Okay, first, that the working group on international contracts finds several forms of various cases. So related to the MOU or the letter of intent is not a single case, but various cases. The second, the working group also try to give a theoretical synthesis of the nature and legal effect of the letters of intent. And the working group also tries to give practical recommendations to negotiators how to make memorandum of understandings. Okay. Let's now move to the study of cases, okay, of the letters of intent. The working group has classified the letter of intent into 4 groups. Okay. The first one, or the first group, is definitive contracts with particular variations. Okay. And the second group, stages in the negotiation. And the third group, MOU, are letters without binding effect and clauses excluding liability. And uh, the fourth group is that the LOI is a firm agreement about certain particular aspects of negotiations. Okay, so these are the results of the working group in classifying the letter of intent. Okay. Research. How about the legal considerations in terms of theoretical synthesis? After the working groups classifies the letter of intent or MOUs into 4 categories, then based on the categories, theoretically, the working groups classifies into first traditional legal categories, and then the second one is the specific letters of intent. What about the traditional legal categories? There are at least 6 categories. The first one is the MOU, or the letter of intent, which can be classified into offer and acceptance. Okay, so the MOU here is a kind of offer and acceptance. And the second one, or the second categories, traditionally, MOU is a promise to contract. Okay? And the third category is definitive contracts. And the fourth is condition precedents. And the fifth, entry into force clauses. And the last one, it is categorized as problems of authority. Okay? Each of the category has its own examples. Okay, so please then read the examples in the sources that I would like to upload in the classroom. Okay. You may see the first category, for example, offer and acceptance. What is it like? How is the structures of the MOUs, and how is the form of clauses, and so on and so forth. It is also for the promise to contract, this is the second category, and other categories. Okay, so each category will have an example. Okay, okay, that is traditional legal categories in the first theoretical synthesis, and the second one, specific letters of intent. So after the working groups categorize traditionally about the MOUs, then the working groups also try to identify the specific letters of intent. The first one related to legal natures, and the second one is contracts to negotiate. Okay, let's move to the legal nature. or to reverse specific letters of intent. Okay. First, in relation to the legal nature, the theory of contract formation has not reached the same degree or stage of development everywhere, nor the same solutions as far as the legal status of negotiations is concerned. So, because of the different degree or stage of development everywhere, then the theory of contract formation has not reached the same degree. It means that about the legal nature related to the MOU or letter of intent cannot uh, be the same because it is different from country to country and from the system to the system of law. In civil law countries, all retain the principle of possible pre-contractuality, okay, in spite of their differences concerning the basis for such liability. Okay, so once again, in civil law countries, it seems that all kinds of MOUs retain the principles of a possible pre-contractuality in spite of their differences concerning the basis for such liability. However, such classical theories have developed without taking into consideration the many varied documents currently examined. In this area, or in relation to legal nature of MOU or letter of intent, English law or common law appears not to develop along the line of continental systems, so different from civil law or continental system. English members of the group have generally been more reluctant than their colleagues to recognize a contractual character to those various agreements attained during negotiations. In general, English courts are prone to give effect to the presumed intentions of the parties, and an intention to negotiate in good faith would appear to be a reasonable interference. Once again, would appear to be a reasonable inference to be drawn of their intention in signing such such MOU. Okay. And at stake, the above discussion is whether the letters of intent may, in certain cases, be recognized to have a contractual status and lead to contractual status and lead to contractual liability in case of breach of the undertakings expressed, or whether they can be relevant only in terms of a possible liability in torts. Okay, then whatever the applicable law, the situation is of course clearer when the drafters of a letter of intent have taken an express position as to the nature of their agreement. Analysis of letters of intent are often based on an all or nothing model. Such documents are qualified either as contracts to negotiate or as non-contractual instruments, possibly relevant only with respect to tortious liability, or apart from contractual liability, it is more tortious liability. Okay. And then the following is the problem of contracts to negotiate. When negotiators specifically express agreements on the development of negotiations process or some of its aspects and do not claim to stay outside law, the interpreter in many cases will be in position to discern contractual elements preceding the conclusions of the contract being negotiated. And it can be seen from the contents. Yeah. What obligations do such contracts created in the course of negotiations engender for the parties? The second one can be seen from the second aspect, that is establishing breach. The rules for establishing breach of contract are far from easy to determine in such a new subject matter. And it can also be considered related to remedies in the event of breach. How can the MOU or the letter of intent determine remedies in the event of breach? Okay. One of the signatories of a letter of intent, for example, breaches the obligation to continue the negotiations in good faith. He breaks off negotiations without further justification, or at least ceases constructive cooperation in search of an agreement. What are the remedies available to his partner? Whether it is whether there is an intervention of an arbitrator or a judge, or the second one, how to assess of damages in terms of the remedies in the event of breach. Yeah. Then the last one is the effect of letters of intent after the conclusions of the contract. So there are some principal legal problems related to letter of intent or MOU, okay, as discussed before. And now we turn to advice to negotiators. Okay, there are some recommendations how negotiators can do or cannot do, or what can be done and what cannot be done by negotiators. The first one, and it is very essential advice, is that legal department should always be present at the drafting of pre-contractual documents, or that it should at least provide a non-legal negotiator with precise instructions about the expression to be used or avoided. So the first advice here is especially aims for those who make an MOU, but they are not a lawyer. Okay? They're not a lawyer. So it is very important that in making an MOU or letter of intent, to involve the legal department or to involve lawyers. Okay. The second one, it is always preferable to express as clearly as possible what is to be binding and what is not. So rather than discussing whether or not MOU is binding or not binding, it is preferable for negotiators to draft the MOU, and in the MOU, there is a clear expression about what is something binding and what is not. Okay. And another advice is that if one wishes not to be bound, while intending nevertheless to establish some document recording the progress of negotiation, it is preferable to say so. So in this case, even though it is in the MOU or in the letter of intent, the firm wording is recommended. Okay. If one expects the letter of intent to give rise to certain obligations, it is better to express precisely the purpose of those obligations. Okay, and then it would be better also to stipulate at the start of the negotiations that the various pre-contractual documents will not be binding unless and to the extent that this should be expressly stated. So binding or not binding, it should be stipulated in the clauses of the MOU or in the letter of intent itself. Okay. A number of documents examined by working groups illustrated the importance of a set procedure for the negotiations, in particular, so far as concerns fixing time periods for various phases. A clause covering the confidentiality of information exchange seems necessary in certain cases. The definitive contract ought to contain a clause relating to the letters of intent and other documents that have preceded it, either to establish their value for interpretations or to deprive them from the start of any legal effect. Letters of intent should be drafted in a way that would prevent one partner from claiming that the concluded contracts had already entered into force. And finally, the problem of which law should apply should not be ignored by the negotiators, for legal effect of the various stages in the conclusions of the contract is not precisely the same from one country to another. Okay, that's all for today, and next meeting we will discuss about how is the binding force of letter of intent or MOU under Indonesian law. So please read the materials related to Indonesian law concerning the position or the status of MOU and or of the letter of intent under Indonesian law. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon.